Hi guys! Welcome to my channel. My name is ReadingBear and I hope you are ready for some more stories. And today, we'll take a look at some new legal advice content. If you enjoyed my content, please don't forget to subscribe to my channel and post some bear emojis in the comment. And now, let's dive right into the stories.
The first one is titled, After 60 Years, Property Retailer is Claiming They Own the Mineral Rights and Will Be Exercising Them. Tennessee. Okay guys, here's a good one for you. Hits a little bit of everything. Tree law, rock law, property sales, legal conflict of interest, ethics complaints. Might even do a shitty MS Paint drawing. Located in small town Tennessee. 60 years ago, my grandmother bought a piece of undeveloped wooded area about 50 acres in size. Nothing fancy, something to be left to the family when she passes. Fast forward to this year. Douchebag Properties, DBP, is claiming that they own the mineral rights on that piece of dirt and that they are going to be exercising those rights to remove rock off the property for sale. They want us to sign a hold harmless agreement and a bunch of paperwork essentially saying that if anything goes wrong it's not their fault, not their problem, and the property owner takes full liability. And they need this contract signed as soon as possible because they want to get started before the weather turns cold. Basically, trying to pull a fast one on a 90-year-old grandmother. We did some digging. Apparently, they do own the mineral rights, future lawsuit incoming. Original seller claimed was selling mineral estate and surface estate. Title search came back clean. Not sure about statute of limitations or how the hell these a-holes got the rights to begin with. So, we know we can't stop them from getting the rocks. Sucks but lesson learned. Honestly, it's not about the mineral rights. It's more about them coming onto our property, taking what they want and leaving a mess behind for us to deal with. After talking it over with my grandmother, this is what we want to happen before any work is done. 1. Full survey of the property done by a land surveyor to determine boundaries that the contractor cannot pass. 2. Full survey by an arborist of all trees on the property and an estimate of their value. Any trees that are removed or destroyed must be paid for and replacements planted. 3. All work completed within 1 calendar year with a daily penalty for any work past that, including cleanup and remediation. They really don't want to give us an estimate of when they will complete the work. Lots of about a year or when the work gets done. 4. $2 million liability insurance policy on both DBP and the contractor. I don't want to be involved if these assholes drop a barrel of diesel into a creek bed and the EPA comes knocking. Or the DOT gets pissed those heavy trucks are tearing up the right-of-way. 5. After 1 year, all mineral rights transfer back to property owner and DBP never darkens our doorstep again. So, because we are dealing with small-town Southerners where everyone knows everyone else and the concept of outsiders are very much a thing, we found a law firm in a different city, county that hopefully had no relation to DBP or the contractor they hired to dig the rocks. We bring up our concerns. He says that he has never worked for or done business with either DBP or the contractor, pay his fee, and expect him to represent us fairly. But I'm starting to get the feeling that this guy is not on the up and up. He tours the property with DBP and the contractor without their lawyers and without telling us changes nothing about the contract that they want us to sign and is also now really pushing us to get it taken care of as soon as possible. As in calling and texting multiple times a day saying that it's a good deal and that we need to move fast. First, we did not give permission for anyone to be out there without us being notified and on site. I don't know if it's normal for lawyers to do location visits without notifying the owners, so maybe that's just on me. It set me off. Stay off my lawn. Second, it's been 60 years since we came into this land. What's the rush? I'm not going to take the chance on signing something that's not in our best interest without going over it with a ducking magnifying glass. After losing faith in this lawyer, we reach out to my aunt who is a non-practicing property lawyer in another state. She takes our demands, legalized them up, and then forwarded it to our counsel stating that we expect him to work in our best interest, not DBP's. That's where we are now. So, this was part rant and part question. Am I missing something obvious? And am I expecting too much? I know that we most likely will not get everything and if they do own the mineral rights, they are going to get the minerals. But I don't want some fast talker taking advantage of my grandmother because she is old and an outsider. I also don't want this piece of property to be stripped mined out from under us. Just because I know it's not complete without one. Update. A kinda update to this post. This is a bit of a two-parter. First part. On the subject of rocks. So, after a few evenings of Google and I getting to know each other over some very large glasses of scotch, I found more than a few cases that says that this company pushing to mine the rocks as minerals are full of crap. First, what they want to mine is called dimension stone. It looks like this. Second, this rock is not a mineral that falls under minerals rights laws. As discussed in Heinemann vs. Terra Enterprises, LLC, 817 F. Sup. 2D 1049 ED 10. 2011, the United States District Court in Chattanooga ruled that rock does not constitute a mineral. Substances such as sand, gravel, sandstone, and limestone are not minerals within the ordinary meaning of the word unless they are rare and exceptional in character, blah blah blah. While they might own the minerals rights, we are still determining if this is true. Those include oil, gas, coal, etc. Not rocks. Now the Ahole who wants to do the mining texted us that it was his intent to quarry stone out of the property. Note that he did not say mine stone out of the property. Mining and quarrying are two very different things in legal circles. Even if rocks were considered a mineral, State of Tennessee vs. LaHare Hill, LLC, stated that if the extraction of the substance in question is necessarily so destructive of the mine's surface area as to essentially destroy the conveyance of surface rights to that area, then the company does not have the right to perform the proposed extraction at all, regardless of whether the substance is a mineral, and regardless of whether the extraction method is the usual, necessary and convenient means of removing said mineral. General mineral reservation in a deed will not be construed so broadly as to include extraction methods that destroy the surface rights conveyed in the same deed. If a grantor wishes to retain the right to obtain minerals through destructive surface extraction, he must explicitly reserve that right within the deed. A general mineral reservation will not suffice. So, rocks aren't minerals. And even if they were, minerals rights don't count because if you dig them up you destroy the surface and therefore the surface owner's rights. Second part. On the subject of the shyster lawyer. Now this gets interesting. After a few weeks of total non-communication from the lawyer and more than a few texts from the Ahole trying to quarry the stone about not needing lawyers involved, it was time to step up our game. One of Grandma Snow's daughters is a non-practicing lawyer in another state. So, I call her up, tell her about this lunacy and give her the rundown on the cases that I found during my scotch-fueled Google rage. She tells me that it's hit or miss and that she would not be able to represent us anyway because she is no longer a part of the bar in TN. But she is willing to look over the cases and get back to me. 2 days later she calls me up, tells me that I should have been a lawyer, and then sends me a copy of the cease and desist she wrote and overnighted to all the involved parties. Holy crap, I would not want to be on her bad side in a courtroom. Trial by combat might be safer. So anyway, Aunt Lawyer sends a copy of the C&D to Shyster and said that she has reviewed the timesheet for what we paid him and had some very serious questions in regard to his billing. Specifically, his little field trip to the property to meet the miners without prior authorization, his failure to provide all correspondence with the opposition for her records, and why he seemed to be on a first-name basis with all the other parties on what official correspondence we do have. Shiesty responds back with a threat to report her to the other state bar for interfering with his client. Now just so we are clear, Aunt Lawyer is Grandma Snow's daughter. I'm not quite sure where he was trying to go with this threat because it's not like she went and started filling things or appearing in court. Aunt Lawyer responds with, I think I can speak to her and speak on her behalf without having to ask you. More drama ensues, lots of legal threats, threats of ethics reports and then nothing. It has been radio silence for the past month. No word from the property retailer, no word from the miner, and no word from Shiesty. As it is right now, we are assuming that the value of the rocks is just not worth the effort or the legal fight to get them. That might change in the future, but as of right now, there is nothing. I finally convinced Grandma Snow to get a trail camera to watch over the entrance of the property. Any trespassers will get reported to the police and hopefully that will be the end of this mess. Thanks for everyone who commented on the previous post. I will continue to update if there are any changes. The last one is titled, Recently settled a custody dispute and finally have my first overnight. Ex and her husband insist on entering my residence and I insist that they not. What can I do? Edit. Wow, this blew up. Thank you to everyone who offered advice and voiced support. I'll be contacting my city's non-emergency line today to request an escort and/or info regarding neutral drop-off locations. Will update if anything particularly exciting happens. As the title says, I recently settled a custody dispute regarding my 7-year-old child. The order states that my child will spend the night at my residence this upcoming Saturday. It does not state anything about his mother being able to enter my residence at any time, nor does it allow for verbal communication without express written consent. To be clear, I completely understand a mother's desire to see where her child will be staying, especially when our child has not spent a night with me in over 4 years. However, the only reason she's allowing it now is because after 2 rounds of mediation, an ADR hearing, and upon completion of the discovery process, it became abundantly clear that I was going to get more or less everything I was asking for in my proposed parenting plan. She attempted to negotiate an ability to enter my residence into the settlement, but due to her behavior throughout the process, my attorney specifically advised me to not allow her to enter my residence. She has a documented history of misrepresenting facts and presenting false allegations. Now with my first overnight coming up, she and her husband are texting me, each separately and in a combined group thread, stating that I'm crazy for not letting them in and that it's their right, blah blah blah. I have made them aware that I do not consent to them entering my residence, and I know that I'm under no obligation to grant them this request. I'm also aware that if they decide that my child can't spend the night with me, that my ex is in contempt. When they made it clear that they would attempt to enter my residence, I insisted on picking him up from their residence, but they are firm on transporting him here. What is the absolute best thing that I can do in this situation? Can I hire an off-duty cop to supervise the transition? Should I ask a friend who my ex is familiar with if he can be present to witness the transition? If I'm being completely unreasonable, I'll take those opinions too, but I'm not letting these people into my house. Update. I called my city's non-emergency line on Thursday to inquire about civil standbys. The operator gave me some great information, and I got really confident that all would go according to plan. I also contacted a friend who my ex knows and has a neutral positive rapport with, and he came by for moral support and to be a third-party witness to the whole ordeal. Side note, my God, I am so happy that I have this guy in my life because he was the absolute perfect person to have with me for the whole ordeal. If you're seeing this, man, thank you again. This morning ahead of the exchange I called my city's non-emergency line back as instructed, and they dispatched officers to my residence. When they arrived, they informed me that because there is no order for supervised exchanges or a peace protective order in place, they were not going to be able to provide service as requested. Big ducking bummer, but not the end of the world. My buddy showed up, I brought him inside and showed him around the place since my ex knows him. I hoped he may be able to vouch for my living conditions, and we prepared for their arrival. They showed up a little bit later. I got my phone out, started a video, put my phone in my breast pocket, and we went outside on the sidewalk to attempt the exchange. Essentially what happened is I reiterated my stance. They were not welcome inside, and I would be taking our child inside per the agreement that we both signed and that was signed by a judge. My ex and her husband immediately began raising their voices with my child being held by his mother outside in sub-freezing temperature sand, insisting that they needed to get our child inside because it was so cold out, and they would be coming with him. As I stood firm and calmly repeatedly reminded them that I had no obligation to let them inside and that it would not be happening, they began making threats to call CPS because I was leaving our child out in the cold, that they smelled drugs, and then my ex accused me of looking hungover, which is ridiculous considering everyone is well aware that I've been sober for over 2 years. Anyway, you get the gist. It didn't go well. It was also a very public dispute, and because of the continuously raised voices on the part of my ex and her husband, someone in the neighborhood called the cops. Before they arrived, my ex and her husband threatened to call them as well, which I encouraged, and as soon as they went back to their car to do so, the police that someone else had called showed up. Essentially, the officers informed both of us that they could not force the child to enter my residence without his mom, but that I was fully within my right to deny her entry, and that if she chose to leave with our child, she would be in violation of the court order which I had printed and brought with me, and they would be writing that into their incident report. They encouraged her to call her lawyer, which I believe she attempted but was unsuccessful in doing. She came back claiming that her lawyer stated that, if the minor child doesn't wish to enter the residence without her, then she would not be found in contempt of the order. Literally everybody present knew that that was false and told her that, but she refused to believe it. She then made threats to get $30,000. No, $100,000 from her father to take me back to court. The officers repeatedly informed my ex that she had 2 options. drop the kid off or violate the order. They encouraged her to pick. I asked if she would feel more comfortable if an officer entered my residence to attest to my living conditions. She thought about it for a minute, but did not budge. Her way or the highway. By this time, it had been over an hour of argument. We hadn't gotten anywhere. The police had another more urgent call, and their involvement was proving futile. My ex agreed to go back to her vehicle and attempt to encourage our child to go inside. I firmly believed the opposite was going on. After 20 minutes she informed me that he did not want to go inside unless she could join him. I asked if I could speak to him directly, which she allowed, and I very calmly let him know how sorry I was that this was happening this way, that I know we had both been very excited for this day for a long time, and that I hoped we would still be able to have our fun day together. I asked if he also hoped we could still have a fun day together, and he said yes. So, I asked him if he felt comfortable coming inside, and he said yes, at which point both his mother and stepfather turned around and said, "But you're not comfortable unless mommy comes with you, right?" He hesitated, they both shook their heads to coach him, and he shook his head. They took that as proof that my ex was not in contempt and that we would have to reschedule, and then drove off. Police returned as this was happening and asked if I would like to leave a domestic victim statement, which I did. They gave me my copy, handed me a card with info necessary to retrieve the police report, gave me a little bit of a pep talk, and went on their way. I'm devastated, absolutely heartbroken. I've been looking forward to this day for years. It finally came, and my ex just couldn't face the music and live a life where she doesn't have complete control over mine. I know that I handled this the right way and that I now have a slam dunk case for contempt. I hate that this has to be so difficult. To anyone going through anything similar, you're not alone. This sucks, but we got this. Keep fighting for them kids, y'all.